The Corporate Transparency Act hit us all January 1, and all the experts have been giving us their opinions of this and that, but I kind of waited until March. I wasn't anticipating quite the changes we've had since January 1, but I didn't think they had it quite all figured out in January 1. So we have a lot to talk about, more than what is the Corporate Transparency Act. Well, I also understand it's unconstitutional. We don't know what that means. And we're not really sure what we're supposed to do now that it's unconstitutional. So I have invited Spence Stover. He is an attorney here in Kansas City. He's a business member here with MAREI, and he's done his research. He knows his information, and he's going to tell us what we need to know going forward for the Corporate Transparency Act. So Spence, welcome to the discussion here today.
Thank you, Kim.
And tell us a little bit about you and what you practice as laws, because I know every attorney has a different forte. And so what is your area of practice?
I'm a full service real estate attorney, so I do everything litigation wise in terms of quieting title to evictions. I do transactional documents, contracts, deeds, security instruments. I also do business formation, which touches into what the Corporate Transparency Act overlaps into. And I do some estate planning as well, and sometimes that practice also overlaps into bankruptcy.
Okay, but you're not out there chasing the ambulances or doing divorce law.
Definitely not. I'm trying not to get hit by ambulances or and stay out of divorce. You're correct.
All right, well, cool. Well, I know you have a presentation, so we'll just turn you loose with your presentation. And if we don't understand what you're saying, we'll jump in and interrupt you with questions, if that works for you.
Yeah, please do. And just a heads up, my Zoom, it's been iffy, kind of touch and go the past couple of weeks. So if I freeze or cut out, I apologize in advance, but we'll figure out how to deal with it. But hopefully it won't happen.
All right, cool.
So I mean, the act I plan to discuss what it requires, to whom it's applicable, when it must be complied with, what the penalties are, and with respect to enforceability, I'm going to touch on that case that deemed it unconstitutional. But for starters, I tried to summarize it in a nutshell here, which it's essentially it's a database. It requires specific people who have certain interests in certain businesses to provide identifying information to a secure online database, and that is information regarding both the company as well as what are called the beneficial owners, and we'll get into what that means in a bit. The act it's administered and enforced by the Financial Crimes Enforcement Network, part of the Department of the Treasury. And I'm sure people are wondering why the government's doing this. Well, this is the policy reason. It is basically to prevent criminals and terrorists from using shell companies to further their illicit activities, whether it's money laundering or funneling money to terrorist organizations, that sort of thing. So that's the gist of it, basically. Let's see. As far as the entities, beg your pardon, the entities to whom this applies. The act defines a reporting company, and which is any corporation, limited liability company, or other entity that's created by filing a document with the Secretary of State or a similar office. And that's going to be an important, I think, distinction, for your members to consider when determining whether or not they need to report to FinCEN under the Corporate Transparency Act. And also entities that were formed under the laws of a separate country but are registered to do business in the United States, and they have to file such a document with the Secretary of State or a comparable government office.
So you probably might have this, but my question in there, so my LLC we formed, as that slide said, but my personal planning trust was formed like the last slide said. So do I need to register my estate planning trust as well?
Yeah, that touches on that first definition of a reporting company. It's only an entity that's created or registered with the Secretary of State or a certain comparable entity. So if that trust or other comparable organization is not formed by filing a document with the Secretary of State, then it's not encompassed by the Corporate Transparency Act.
Okay.
It's created by the filing of a document. So most trusts are not created when or by filing a document with the Secretary of State. So a lot of trusts will be exempt from having to report under the CTA. In addition to other entities that are exempt, there are a lot of entities that are already pretty highly regulated by the government, and they're not required to. They have to file all sorts of other documents that provide that similar identifying information. Banks, Wall Street broker-dealers, 501(c)(3) companies. There's another exception for larger companies, and I think I outlined what fits that definition. And I think the idea is that, large companies or Walmart's or ExxonMobil, they're not being used as a shell company by criminal or terrorist organizations. So that probably explains why there's that exception for large companies that employ 20 or more employees in the United States full time, gross receipts $5 million annually, and having an operating presence in the United States. A pretty good distinction to bear in mind or exception are inactive entities. Some entities, will have to register, even if they've been administratively dissolved by the Kansas Secretary of State for not filing annual reports. They may or may not still have to report based on whether they fit the definition of an inactive entity. And there are like 6 elements to that definition. It must have been in existence on or before January 1st, 2020, not actively engaged in business. It's not owned by a foreign person in any capacity or managed by a foreign person, has not experienced any change in ownership in the preceding 12 months, has not sent or received funds greater than $1,000 in the preceding 12 months, and does not hold title to any assets such as real property. So I think that was one question, in addition to whether trusts will have to report is dormant businesses. And if a business meets this definition, all 6 of these elements of that definition, then they will not have to report.
So you have to have all 6 of those?
Correct, yeah.
So if they haven't, if we created an LLC 5 years ago to put an asset in and then we never used it, or we created an LLC because we had a great business idea and then we never did anything with it and it's just sitting out there, it hasn't done any of those things, and it's not owned by a foreign national, we could ignore those?
Potentially, if it doesn't own anything, if it still, has title to some property, then you will have to register it. If it's somehow generated or paid out or received more than $1,000 in the prior 12 months. So you just got to make sure you check all those boxes.
But if it's just sitting out there and has done absolutely nothing other than get created, and it's over 12 months old, we could probably ignore it.
Right. Most likely. And if it was created before January 1st, 2020. So if that entity was created January 2nd, 2020, but otherwise checks those other boxes, I think it would still have to be registered and reported.
I know a few of us have some old companies that we created and never did anything with. So that's a big question.
Yeah, I thought so. I thought that'd be important. So go over your all your entities, even your old ones, make sure they fit all these descriptions, and to make certain whether you'll have to report that entity to the government.
Okay.
As far as the information that has to be reported, there's certain information regarding the entity, the LLC or the corporation that must be provided: the full legal name of the company, any trade name or DBA, street address of its principal place of business, the state where it was formed, and the IRS tax identification number, which is usually its FEIN.
So a question there, what if we don't have a principal place of business? So I have businesses, but they operate out of my computer, wherever my computer may be. I have a mailing address, but I really don't use my home address. Will we give them our home address anyway?
You can, I think it should be your registered agent address, whatever
Okay.
address you placed with the Secretary of State. That could be your principal place of business. Oftentimes, that registered agent is also the registered office for purposes, even though people, especially in real estate, often don't have just a single
Physical
or a steady
building.
office. Correct.
Okay.
Yeah, they do a lot of driving around or do some work at home. And let's see. And it's the other bit of information are who the beneficial owners are. And a beneficial owner of a reporting company is somebody who either exercises substantial control over the entity or owns or controls not less than 25% of the ownership interests of the entity. So if you manage an LLC, for example, but it's owned by a third party, then I think the person who manages that LLC will still have to register as a beneficial owner. Even if, as well as the person who owns the membership interest of the LLC, and my hypothetical.
So, for example, in our LLC, our son does not own the LLC. He will inherit it someday, probably. But he does a lot of our business. So he takes all of the seller phone calls. He goes out and talks to all the sellers, buys the houses, sells the houses. So he has substantial control, yet he has no ownership. So he would have to register as a beneficial owner as well.
Yeah, that's potential. The federal government, they did enact a code of federal regulation that really broke down and defined what it means to exercise substantial control over the entity. So I can provide you with more of that information later. But it was a pretty detailed list, and so I didn't include it in the
Okay.
slideshow. I didn't go into that definition could include.
Okay.
Now, with respect to a beneficial owner of a reporting company, and so far those are kind of our key definitions: reporting company, companies that are subject to the CTA, and beneficial owners who are people who have some interest in those reporting companies, and as far as what their information that must be reported includes all this information: the full legal name of that person, their date of birth, current residential or business street address. And from what I've read, it's a business address if the beneficial owner is another entity, an LLC owned by another LLC, for example. But if that beneficial owner is an individual, then it must be their residential address. And the other piece of information is that must be provided as an acceptable identification document, which is basically a non-expired document issued by any sort of government entity. United States passport, driver's license, other government ID. If foreign national, then passport issued by a foreign government. And I believe that they take an image, of that identification document and part of the reporting process. With respect to reporting beneficial owner information, they have created a means of the government giving beneficial owners a specific identifier called a FinCEN identifier, and FinCEN, as was set forth in an earlier slide, is an abbreviation for the Financial Crime Enforcement Network as part of the Treasury Department, and they can provide give somebody their own personal identifier number that can be provided in place of having to admit all of the information required by beneficial owners that was set forth in that prior slide. And I think that really was created so that people who are beneficial owners of several entities can just have that one FinCEN identifier and provide that every time they had to report, as opposed to going through that long list with their full name, address, date of birth, and again, providing another acceptable form of identification.
Okay. And we probably need to protect that FinCEN number like we do our social security number, because if somebody gets a hold of that somehow, could they access all of our information with just the number, or do they need more information?
Yes, I think you would have to keep a hold of that. Yeah. Yeah, it probably would have to. As far as, accessing that boss system, I don't, it's not information that's stored. It's not released to the general public. And if somebody, I'm not even sure. I haven't had to access it yet. I'm going to wait to see how this plays out in the courts. But I'm not certain if, for example, let's say I register my report my LLC, if I'll be able to go back on that network and see my LLC's information, or if I just use this spin send whenever I submit information. So I don't know if I'm going to be able to even review my own information online. But this is definitely, at least for submitting information to the government.
Okay.
Now the deadlines are going to be pretty important. Entities that were created or registered to do business on or before January 1st of this year must report by no later than January 1st, 2025. Companies that are created in 2024 must register within 90 calendar days of creating or registering the entity. And then starting next year, entities created must report within 30 calendar days of their creation. There is no requirement to file regular reports like in Kansas. LLCs must file annual reports. So there's no requirement, still comparable requirement, but it is important to bear in mind that if there is some sort of a change in the information previously provided, then that change must be reported within 30 calendar days that the change into effect.
So new owners or new address.
Yep.
Owner dies.
Yep. Changes names, new owners, new managers, that sort of thing. Yeah. Everything that was previously reported.
What if, and this is the case in many of my companies, I'm sure, our LLC is owned by a trust. It's not actually owned by a real person. So we'd have to register the trust. And then that the entity is owned by the trust instead of.
Yeah. That's correct. That's correct. So yeah, it would be the trust nation. Yeah.
We've been doing a lot with trusts lately, so I have lots of trust questions. Okay. And Brendan's diligently taking notes, so.
So as far as disclosures, government employees and officers, as well as financial institution employees and officers, may not disclose any beneficial ownership information except upon request of a government agency in the course of a criminal, national, or civil investigation, which goes back to the previous stated purpose of the CTA, which is to prevent money laundering and other criminal activities. There's another exception that could be if there's a request from a financial institution and the customer provides permission to that institution. Usually when applying for credit, perhaps a bank will require reviewing the information provided and reported via the CTA. Then in that instance, the government may release that beneficial ownership information to the bank if the customer gives a permission. But beneficial ownership information is not accessible to the general public, not subject to the Freedom of Information Act or other government laws. And the act does set forth some pretty stiff penalties if this provision, the non-disclosure and disclosure provision, is violated by an employee or officer. So your information will not be just readily available to anybody to access online.
Unless hackers get it.
And there is a provision in the act that addresses that, but it's a very vague provision that says if we get hacked and they have to present some kind of report to Congress, but it wasn't very detailed in terms of how they would react, but that possibility at least was contemplated to some degree when the legislation was drafted.
To deal with that. All right. But that doesn't solve the problem if we do get hacked.
Exactly. At least you don't have to report social security numbers, so that information will not be stored on the database. With respect to penalties, I'd like to emphasize that it did include the modifier willfully. If anybody willfully provides false information or willfully fails to report, there are some potentially stiff fines. Of course, it still it still needs to be seen how the government will enforce this provision, but people who are found to have willfully violated the act could be liable to the government in a civil penalty in the amount of not more than $500 for each day the violation continues or has not been remedied. There's also potential criminal penalties, fine up to $10,000 in imprisonment for not more than 2 years or both. So there is the potential of there being penalties. I'm going to assume there would be quite a bit of discretion not to penalize people on the far end unless they were really involved in some illegitimate and or illegal activity.
So the little old lady who just forgot, she wasn't being willful, she just forgot, and they would probably give her a waiver, I would bet. That's my impression of what willfully means.
Exactly. But it's still best to be, to exercise due diligence, but it isn't, I think it is important that they put in that the willful state of mind is required for somebody to be held liable civilly or criminally under the act.
Okay.
So we're going to move on to the recent case that's been of much interest that held that the act was unconstitutional. Just came out March 1st. It was a United States District Court in Northern Alabama who ruled that Congress exceeded its constitutional authority when it enacted the Corporate Transparency Act. The scope of the judgment, it just prohibits the government from enforcing the CTA against the named plaintiffs in the lawsuit. So those of us who are not plaintiffs, we are not protected by its holding. And as far as who could be considered a plaintiff in that suit, there's a gentleman named Isaac Winkles. Any reporting companies or beneficial owners for which Isaac Winkle is an applicant, the National Small Business Association, and members of the National Small Business Association as of March 1st, 2024. As far as what the impact of that case is for those of us who are not named plaintiffs, I think if we respect to our entities that were created January 1st of this year or earlier, we still have some time to at least monitor the progress of the case as it's appealed. So we might have a better idea before the deadline. Excuse me. Before that deadline on January 1st, 2025, whether we will have to report. So I think we're definitely we're not in a hurry, but we're starting new companies this year. We'll only have 90 days to report, so I don't think we'll have the luxury of seeing how the court cases play out. And the notice, I did see that FinCEN issued a notice that states per the court's order, they will not force the CTA against any of those named plaintiffs. And it seemed to specify with respect to members of the National Small Business Association members as of March 1st, 2024. So I read that provision as stating that we can't just join the National Small Business Association and avoid complying with the TA requirements.
You need to have been a member before they handed down their judgment.
Yeah, precisely. That's how I read it. Otherwise, according to the government's notice, that they would still according to the government's notice, they would still consider any other entities subject to enforcement under the Corporate Transparency Act.
So if we're starting an entity next month, then we need to comply because we got the 90-day rule. But if we have an entity that existed before the beginning of the year, we can kind of hang out and wait and then see what happens between now and say October, November. And if nothing's happened by then we should start considering this because they might not have an answer until say June next year. So we might be, do you think it will take that long for them to do their further court judgments, or do you think it'll all be taken care of before the end of the year?
I think we'll have some appellate court rulings that may give us a clear idea whether whether those of us who are not members or parties to a lawsuit will have to comply with the Corporate Transparency Act. I think there will be some decisions issued in some federal circuit courts of appeals, which may have broader effect and implication than this district court judge's ruling. I imagine this will eventually get to the Supreme Court, but I'm not certain whether the Supreme Court will have made a final ruling with respect to the CTA by the end of this year. But I think we'll have some courts of appeals decisions for certain.
So the appeals might say, we still don't know, so we're going to hold off on making you do this until we know, or we might all be scrambling on December 31st to get registered.
You know, there may be a court of appeals ruling that states that it's unconstitutional, and there may be a separate ruling saying while the government appeals to the Supreme Court, the Corporate Transparency Act is not enforceable, or there could be a separate part of that instead states while this matter is still not resolved by the Supreme Court, or while the government appeals to the Supreme Court, but the Corporate Transparency Act is still in effect. So still a lot to be seen. How the courts of appeals rule, as well as what orders they give regarding the enforceability of the act, while this, in the meantime, until the Supreme Court issues a final ruling.
So very unthought out requirements, and they're changing the rules as they go, and then the court might change them still. So this is what we have right now as of today. The other question I had, some of the experts are like, oh, you need to run out and hire an attorney to help you do this. And then other people like Brendan says, I just went online and signed up. So do we need an expert to help us do all this, or is it fairly simple and easy for us to do ourselves?
It's probably pretty comparable to filing documents with the Secretary of State.
Okay.
And I'd hope to do this myself, so I guess a personal experience and relay that to you as far as how simple it is, or if there are any, I don't know, glitches or nuances. But due to this ruling, I'm going to hold off until the end of the year before I register.
Okay.
Hey,
All right.
and Kim, in full disclosure, I just signed up for my FinCEN number. I didn't actually file the, what Spence is talking about today. I just did the FinCEN number. And it was just like your name, address. You have to upload some kind of identifying documentation. So I used my driver's license, but it takes like, I don't know, 4 minutes, not very long.
And then you have that number.
And then you have that number per, yeah. And so I did that for myself, and then my wife, we did one for her because she has her own entities too. So then when we file for all our entities, we can just use that number to do it easily, like Spence said.
And for those of you who don't know Brendan is a real estate investor, a member of MAREI, and the president of Landlords of Johnson County. So that's why he's talked about this at his group a little bit as well. So, are there any questions out there on Zoom land, or did you have any questions, Brendan, that we haven't touched on? I think we've covered a lot of it, but I don't know if there's any other questions.
Yeah, he covered a lot of it. One of them was, should we file now, or what would be your advice on filing now? But you kind of covered that. I guess my question when this first came out was, we all do, well, in real estate world, we all do LLCs for liability purposes, but you don't see this affecting liability at all, right, Spence? I mean, this is more just identification, but you still have the same protections if you have those if you have those LLCs and whatnot in place, right?
Yeah, I agree. I think this act is completely mutually exclusive of the personal liability protection that an LLC can provide.
Okay, that's good.
So the courts can't go use this information or access information to find out who owns the LLC. This is only for the FinCEN people to be able to access the information.
Yep, correct. Pretty limited access is allowed. It's I don't see any requirement or provision that enables courts to enter that order. Just basically investigative government entities, and in certain situations, financial institutions, if they request that information when applying for credit or some other purpose.
Okay, and then I've heard on several of my other informative calls that because it's another database, because it's another place we're putting all of our personal information, I've heard several experts are telling us that we might want to investigate or invest in fraud protection, credit protection. What are those called? But basically insurance in case our identity gets hacked. Would you recommend anything like that, or trust that the government will not get hacked?
Well, I can't trust that it won't get hacked. I mean, I think we've seen that already happen. It might. I mean, it's always a good idea. These at least they don't have social security numbers, so that makes it. I would be a lot more assured. I think it's difficult to really do some damage to the people's identity without the social security numbers. But they will have possibly, I guess, in most cases, a driver's license number. But I don't know. This should be. I don't think this is certainly not an additional incentive for me to purchase that sort of insurance.
Okay, I've had some that were like, oh, you need to go get insurance in case your identity gets hacked, and I'm like, well, my identity's been hacked and like 10 times in the last 2 months, according to all the emails and letters I've received, and in the last, I have one of my emails that's on the dark web. It's been there for 20 years, and I'm like, I don't know what I'm supposed to do with that, but they keep telling me. So
Yeah, and I have my my identity monitored by Experian. So I get those notifications all the time and tell me my phone number is on the dark web or my email address or something along those lines. So I think a lot of that basic information is probably pretty well known. I mean, I don't like that they have our dates of birth on there up there, but it's still something else to bear in mind.
okay. Dwayne has some questions. If I registered an LLC in Kansas as a foreign entity of an Arkansas corporation, do I have to report both the LLC, the foreign entity registration, as well as the Arkansas LLC, or is it just reported as one entity?
Just the Arkansas, just the state
The
of
original.
origin, yeah.
Not
And
the foreign entity or the DBA. Okay.
DBA, I think you have to include that in the registration. I don't think you need to mention that it's also registered in Kansas. The requirement with respect to foreign entities registering, I think that's international, not from one state to the other.
And then if they've created an LLC that they don't plan on using, do they need, and they've created that since January, then they need to comply with that new one, even if they're not using it.
Yep, that's correct.
Okay. All right. Well, I think we've got all the questions. Unless there's any more, I think that's it. I thank you for joining us and educating us. We will be sharing the replay out on YouTube and through the calendar. So if you wanted to re-listen, and we'll also be sharing the slides. So if you wanted to go back and read these more in depth, you can do that. It's as a PDF, not as a PowerPoint. So you should be able to read it on any device out there. And I thank you for joining us. We'll catch you next time.
Thanks for inviting me to speak with the groups, Kim. I appreciate it.
All right. Thank you.
Yeah. Thanks to
And
both. See you guys.
Thank you.
Take
Thank you
care.
for everybody online joining us as well.
Great day.